5, 4, 3, 2, 1. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he may be not guilty, he faces the danger of conviction because he does not know how to establish his innocence. If that be true of men of intelligence, how much more true is it of the ignorant and illiterate, or those of feeble intellect? If in any case, civil or criminal, a state or federal court were arbitrarily to refuse to hear a party by counsel employed by and appearing for him, it reasonably may not be doubted that such a refusal would be a denial of a hearing and therefore of due process in the constitutional sense. Additional evidence at appellate stage is permissible in case of a failure of justice. However, such power must be exercised sparingly and only in exceptional cases where the court is satisfied that directing additional evidence would serve the interests of justice. It would depend upon the facts and circumstances of an individual case as to whether such permission should be granted, having due regard to the concepts of fair play, justice, and the well-being of society. Such an application for taking additional evidence must be decided objectively to cure the irregularity. The primary object of the provisions of Section 391 CRPC is the prevention of a guilty man's escape through some careless or ignorant action on part of the prosecution before the court, or for vindication of an innocent person wrongfully accused, where the court omitted to record the circumstances essential to elucidation of truth. Generally, it should be invoked when formal proof for the prosecution is necessary. Thus, the additional evidence can be taken at the appellate stage in exceptional circumstances to remove an irregularity where the circumstances so warrant in public interest. Such power is exercised to have formal proof of the documents, etc., just to meet the ends of justice. However, the provisions of Section 391 CRPC cannot be pressed into service in order to fill up the lacunae in the prosecution's case. In the instant case, the electricity and telephone bills have not been proved at the time of trial. The High Court, while hearing the appeal, remitted the matter back to the trial court to allow the prosecution to prove the documents and give opportunity to the prosecution witnesses.